Okay, can everyone hear me?
Yes.
Yes. Yes.
Yes.
Hello? Okay.
I'm going to give it just 1 or 2 more minutes because at this point we do not have any attendees. See if we can give everybody a few minutes to get in, and then we will open up the hearing because Vanessa nor Dennis are here. Right. I put the meeting ID in there for today. So should I repost today's? It's not going to let you do it. I don't know. There's Vanessa. Dennis. Okay, good. Okay.
Hi, Laura. It's Vanessa. Can you hear me?
Yes.
Thank you.
Interesting. Oh, it is clickable. Okay, I was just checking to make sure that the meeting was posted correctly for people to get in because we have no attendees at this point. And it appears to be good, so it does have to be double clicked though. Are we okay to get going without having attendees in attendance?
Is there anybody that you had information regarding that they were planning to attend who is not here?
No, there was a couple that had said that they wanted to attend it yesterday, but then they realized it was live on RCTV. So they decided they didn't need to be on here.
Okay.
So my thought is no.
Okay. Well, then in that case,
Laura?
Yep.
Sorry to interrupt. I've just been informed by someone who was trying to get in that they're not able to from the public.
And what did they say on why they can't?
Let me find out. She said she sent you an email. She didn't tell me why or how.
Just now?
Yes, literally seconds ago. I'll call her and find out what's happening. Might explain why nobody else is in.
So, she's getting the same message yesterday. The host has another meeting in progress.
Well,
Yeah, I think it's the same error message as yesterday.
All right, invite. I just fixed this like an hour ago. Everybody get to see my screen?
yeah. Yes.
Um, so let's try and see if we can fix it again. Okay, so now ask them to refresh their screen and try it again.
Laura, I've gotten a message that that link requires people to register to attend. So is someone monitoring that in real time to ensure that anyone who wants to get in?
It's an automatic registration. So once they register, they get in.
Got it. Thank you.
Okay, so before we, Dan, the information that you wanted to share, does that have to be done after the hearing is opened?
Yes.
Okay. All right, now they're starting to get in. Thank you. Thanks, Kevin. So Vanessa, if you can pass the word to the individual that was trying to get in, for that individual to pass the word, that they have to go to the new posting.
I will do that. Thank you.
I swear I just did that an hour ago. I swear that under the penalty of perjury. All right, yep, they're starting to come in. Okay, so
Laura, I'll notarize it for you also.
well, thank you. All right, we're going to wait one more minute and then we're just going to go ahead and get started. The attendees are slowly coming in. I'd just like one of these meetings to start off without a hitch.
If it makes you feel any better, it's not much better in the corporate world.
Watching it on RCS is a good suggestion.
Okay, we're going to go ahead and get started. I now declare this public hearing reopened at 4:12 p.m. Good afternoon. My name is Laura Jem. I am the town clerk of the town of Reading and the chair of the town's board of registrars of voters. I will be serving as the chair for this hearing. This is the second day of the hearing. Yesterday afternoon, the board opened this hearing for the purpose of training and practicing on the web-based technology through which this hearing is being held. This hearing is of the Board of Registrars is being conducted remotely consistent with Governor Baker's executive order on March 12th, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, we are complying with the executive order that suspends the requirement of open meeting law to have all meetings in a publicly accessible physical location. All members of the public body are allowed to and encouraged to participate remotely. The executive order, which you can find posted with agenda materials for this meeting, allows public bodies to meet entirely remotely as long as the public body makes provisions through adequate alternative means to ensure interested members of the public are provided reasonable access to deliberations of the meeting. As a preliminary matter, I need to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond with an affirmative. Make sure that you're unmuted to do this. Chris Holmes.
Sorry. Here.
Harry Simmons.
Here.
Nancy Zimlak.
Here.
Participants, when I call your name, please respond with an affirmative. Mr. Newman.
Yeah.
Ms. Alvarado. Ms. Alvarado. Ms. Alvarado.
Present?
Mr. Insminger.
Here.
Town Council, when I call your name, please respond in an affirmative. Ray Miaras.
Here.
For this meeting, the board is convening by video conference via Zoom webinar as posted on the town's web meeting calendar and the board's agenda, identifying how the public may join. Please note that this meeting is being recorded and that some attendees are participating by video conference. Accordingly, please be aware that others may be able to see you, and take care not to screen share your computer. Anything that you broadcast may be captured by the recording. Having observed those legal requirements, I would like to thank everyone for taking their time to be here. This is a matter of significant importance to the town. On behalf of the board, I would like to thank the hearing participants and the members of the public who have submitted materials or are present at this hearing for taking their time to contribute to this hearing. As the board and hearing participants know, this is our second day of hearing. Yesterday, the first day, our agenda was limited to the ensuring of the board and participants are familiar with the web-based technology we are using due to the ongoing COVID-19 public health emergency. Yesterday's practice session allowed us to identify and resolve any technology issues. A little bit of background. As we begin, I would like to provide some brief background concerning this hearing to those of you who may not be familiar with it, including members of the public who are viewing this hearing through Zoom. This hearing concerns a petition for recall of the town select board member, Vanessa Alvarado. The Massachusetts general laws do not contain any provisions authorizing the recall of local officials. Instead, recalls must be authorized by local charter or by special act from the Massachusetts legislature specific to the town. In Reading's case, the recall of town officials is governed by the town charter in section 8.11. Pursuant to that section, the recall process begins with the filing of a recall affidavit by a specific number of registered town voters that contains the name of the town officer whose recall is sought and a sworn statement of the grounds upon which the affidavit is based. The board reviews that affidavit, and if its filing is supported by the required number of signatures, the board certifies that it issues a blank recall petition forms. Those forms must be signed by at least 10% of registered voters and returned for certification by the board within 21 days of filing the affidavit. Here, the town clerk received an affidavit requesting the recall of the select board member, Alvarado, on February 20th, 2020. The board certified the signatures and the clerk issued blank recall petition forms on February 21. Those petition forms were timely returned to the town clerk and the board certified those forms containing 2,239 signatures, which exceeded the 10% of the town's registered voters. Accordingly, on March 19, 2020, the board issued a certification of that petition. Select Board member Alvarado objected to the board's decision to certify both the affidavit and the petition and requested a hearing before the board as those objections. The board determined to hold such a hearing and issued rules and procedures to govern hearing conducted in open meeting as required by the general laws. Under those rules and procedures, the hearing participants have provided relevant information to the board and to one another, and following those disclosures, Select Board member Alvarado has withdrawn her objections to the recall petition, leaving only her objection to the recall affidavit for deliberation by the board. We are here this afternoon for the board's hearing to consider those objections to the recall affidavit. The hearing will proceed in 3 phases. First, the board will receive evidence from the hearing participants. Ms. Alvarado, represented by her attorney, Mr. Dennis Newman, and Mr. Daniel Emsminger, who has agreed to represent the position of the recall petitioners. Once the board has received all evidence relevant to the objections before it, the board will second allow Mr. Newman and Mr. Ensminger to give a 15-minute oral argument to the board concerning the evidence and why it favors that party's position. Finally, third, the board will deliberate with respect to the evidence and argument it has received. At any point during any of these phases, any member of the board may ask to pause the presentation to ask a question. Before we move to the first phase, some ground rules. Because we are conducting this hearing on a web-based platform virtually, it is important that everyone behaves civilly toward one another. If you wish to speak, please signal to me as the chair that you wish to do so. Do not interrupt other speakers. Please otherwise conduct yourself with the decorum that you would use if you were in a court of law. If you are referring to a document, please start by stating the document to which you are referring with clarity and identify to the best of your ability the specific portion of the document that you are discussing. Once you have done so, please pause and wait for me as the chair to ask you to proceed. This pause is meant to ensure that each member of the board has time to find the document you are referring to before you speak about it. Please treat all others with civility and respect. I received a complaint following yesterday's hearing session that an obscenity may have been made. Please note that as chair, I will police such conduct and act accordingly. At this point, I am going to pause to ask if either of the hearing participants may have any questions of me as the chair before we proceed to the first phase of the hearing. Any participants have any questions?
No?
Okay, Dan?
Yes. Thank you. I'm going to ask the indulgence of the objecting party to perhaps go an extra minute over in my talk, and I'm certainly willing to give them an extra minute also, if that's acceptable.
Is that acceptable of the board? Harry, is that acceptable?
That's acceptable.
Nancy?
Sorry, yes, that's acceptable.
And Chris, is that acceptable? Okay.
Thank you very much.
Any other questions? Dennis, go ahead.
It's acceptable to me.
Excellent.
I'll even cut mine 1 minute short, so it'll still be a half hour. How's that, Dan?
I like it.
I think that Dan, after this, is going to file to apply to law school, actually.
His second career. Okay, so we will start this hearing by accepting into evidence and record the basic documents. For those members of the public who are viewing this hearing, the documents we refer to in the prefix basic are certain documents previously created and received by the board and that are relevant to our issues that will be automatically entered into record. Once again, those documents are available on the town website. I move that the board receive into evidence and enter into record for this hearing those documents identified as Basic 1 through Basic 11 in the board's previously adopted hearing procedures. I need a vote from the board. Harry?
Accept.
Chris? Nancy?
Accept.
Excellent. Next, we will review the hearing participants' pre-hearing submissions. I will start by asking each hearing participant if they have an objection to the board's receipt into the evidence and in its record of any of the other participants' submissions. Mr. Anspringer, do you object to the receipt into evidence and the record any of Mr. Newman's and Ms. Select Board Alvarado's pre-hearing submissions?
I have no objections.
And Mr. Newman, do you object to the receipt into evidence and the record of any Mr. Enspringer's pre-hearing submissions?
No objections.
Thank you. I will now ask if anyone else present at this hearing wishes to offer evidence to the board. And I also want to tell the public, anybody that's an attendee, at some point I may ask for your any comments from the attendees. And in order for you to be recognized, you'll have to raise your hand. That doesn't mean that you will be recognized, but it just, if you choose to, let me know by raising your hand. Okay, so now the evidence has already been in place. At this point, we now go into the argument. Is that correct, Ray? Am I doing this right?
You still need to have a motion to accept the evidence submitted on behalf of Ms. Alvarado and on behalf of the petitioners. There were no objections, but you still need to move them into evidence.
So I just need to go one step closer. Having closed, so the evidence at this point is closed, correct? Is that?
No, first you have to move this stuff into evidence.
Okay, so I make a motion to move everything that's been submitted as basic 1 through basic 11 to be moved into evidence.
No, it's not. You've done that part. You have to move to accept the evidence submitted on behalf of Ms. Alvarado, as well as the evidence submitted on behalf of the petitioners.
What Ray just said.
I didn't hear a second.
Anybody second?
Second.
Okay. Harry?
Okay.
Chris? Yes. And Nancy?
Yes.
Okay, so the evidence has been accepted.
Now you can close the evidence.
Okay, thank you, Ray. Having closed the evidence, we will next move to the argument phase of this hearing. Each hearing participant shall have 15 minutes to address the board to argue why the evidence supports that participant's position. Each hearing participant may use that time in any way the participant chooses. It is suggested, but not required, that each hearing participant focus on those issues and evidence that the participant believes are the most significant to the board's decision. At any point during the hearing, participants' arguments any member of the board may interject to ask a question. If the 15 minutes and the board still has questions, the argument shall continue until no questions remain. The objectors shall go first, followed by the representative of the petitioners. Before we begin these arguments, Town Council will address the board and the hearing participants concerning the law as it applies to the objections to the recall affidavit. That way, the hearing participants will have the benefit of that decision and may address it during the argument. Mr. Mraz?
Thank you, Laura. And good afternoon to everyone, and in particular, good afternoon to the members of the board. So we are all clear. The burden of proof in this hearing is on the objector, that is on Select Board member Vanessa Alvarado. That means it is Vanessa's responsibility to provide you with sufficient evidence and persuade you that her position is the correct one. If she has not provided you with sufficient evidence, or she has not persuaded you that her position is the correct one, then she has not met her burden in this proceeding. The objections that you are deciding now are limited to those directed to the recall affidavit. One of those objections challenges the truth or falsity of the grounds stated in support of the affidavit. In my legal opinion, and the opinion I have previously provided to the town clerk, you, the board, cannot review those grounds for their truth, falsity, or whether they are otherwise sufficient to support the affidavit. I base my opinion primarily on a recent decision issued by the Massachusetts Appeals Court in 2018. The name of the case is King versus Shank. That case involved a similar challenge to the grounds stated in a recall affidavit, and the appeals court held that it would be improper for the judiciary to inquire into the grounds stated in support of a recall affidavit. In doing so, the court relied upon past decisions by courts holding the same, including a decision by the Supreme Judicial Court in 1961 in a case called Donahue versus Selectmen of Saugus. I am unaware of any decision by either the Massachusetts Appeals Court or the Supreme Judicial Court that has authorized either the courts or the Board of Registrars to review the grounds stated in support of a recall to determine their truth or their falsity. In my opinion, therefore, the rule against inquiring into the grounds stated on a recall affidavit applies to a board as well as to a court. In my opinion, it applies to you, and I therefore advise you not to consider the truth or falsity of the statements made in the affidavit. I further advise you not to consider the sufficiency of the grounds for recall specified in the affidavit. Both the truth and the sufficiency of the statements in the affidavit are ultimately matters that should be left for the voters to decide. Now, my opinion notwithstanding, the hearing participants may argue that you should adopt a different position, and you should carefully listen to all the arguments, including those that do not agree with my legal opinion. Ultimately, the decision on this issue is yours, and you should reach your decision based on your consideration of the evidence and arguments. Another of the challenges is to the form of the affidavit. By this, I mean a challenge to some attribute of the affidavit apart from its actual substance. For example, the number of signatures or the form of the certification. In my legal opinion, you may consider such challenges, which are directed to the integrity of your process and not to the truth, falsity, or sufficiency of the grounds stated in support of the affidavit. To that end, the sentence of the charter that you are being asked to consider is set forth in section 8.11.2. It says, 250 or more voters, including at least 25 voters from each of the precincts into which the town is divided, may file with the town clerk an affidavit containing the name of the town officer whose recall is sought and a sworn statement of the grounds upon which the affidavit is based. So one such issue derives from the title of the document that is under challenge here. That document does not include the word affidavit in its title. Rather, the title on the document is recall petition. In my opinion, this is a harmless error. The form contains all of the elements that the charter requires. It contains Vanessa's name and a sworn statement of the grounds for seeking a recall vote. Also of note, it includes a blank for, quote, date of affidavit, unquote. Another issue is whether the grounds stated in the affidavit can be sworn by a single individual or must be sworn by all 250 voters who filed it. It is my legal opinion, and the opinion I previously provided to the town clerk, that the grounds need only be sworn by a single individual, and that 250 voters must then file that sworn statement supported by their signatures. I reached my opinion based on the text of the town charter. The text of the charter requires that the 250 voters file the affidavit, which must contain a sworn statement. It does not specify, for example, that they must make and file the affidavit. Moreover, the only item that the charter's text requires to be sworn is the grounds themselves. This text suggests to me that the drafter's intent was not for the voters themselves to make or swear to what they are filing, but only for them to secure such a sworn statement from an individual and thereafter to file it with a clerk as the recall affidavit. I note that the text of Reading's charter differs in this regard from the text of other special acts and charters that courts have examined on this issue. Thus, I find those other decisions of minimal value in interpreting the unique text of Reading's charter. Again, my opinion notwithstanding, the hearing participants may argue to you a different position. You should carefully listen to all arguments, including those that do not agree with my legal opinion. And ultimately, the decision on this issue is yours, and you should reach your decision based on the consideration of all the evidence and arguments. You may hear other arguments or variations on these arguments in the course of the hearing today. Please keep in mind that during your deliberations, you may ask me for additional guidance or for my opinion on any issue, and I am happy to provide it. Thank you.
Thank you. We will now proceed to the arguments. Mr. Newman, you may begin your presentation when you are ready.
Very good. Thank you very much. Thank you to the board. Thank you, Ray. And thank you, Dan, for all your work and all the work the board has done and for deliberation today. The argument is boiled down to one thing, whether or not the affidavit is sufficient and whether or not the petition should have been issued for the recall. As Ray mentioned, the charter says that the town officer whose recall is sought and sworn statement of the grounds on which the affidavit is based. The seminal case on this is Winchester versus the town, Galvin versus the town of Winchester. The history of that was that voters in the town of Winchester wanted to recall 4 school committee members, and they submitted a affidavit that was not sworn, notarized or signed under the pains and penalties of perjury. The clerk refused to issue that petition. In that case, the voters then sued the clerk to issue the petitions. A superior court agreed with them, and then it went to the Supreme Court, and the Supreme Court disagreed and said that the affidavit was not sufficient. And I quote, "We hold that the affidavit seeking recall neither notarized nor signed under pains or penalties of perjury do not comply with the charter." I also ask you if you can review before your deliberation. I filed a brief memorandum on Friday and then resubmitted it this afternoon. Also referred to a case last year, which case of Greenfield. A selectman was, there was an attempt to recall, a city councilor, because Greenfield is a city, and it did not have an affidavit that was sufficient. And under legal counsel recommendation, the clerk did not certify that. I think that both of these cases are parallel to these, and that the clerk should not have issued the petition to recall petitions, and that the purported affidavit does not comply to the town charter, and therefore the board should vote to rescind the certificate of recall and cancel the election. Dan, I think, has pointed out in his brief, and also is that 2 things. One, that it wasn't timely filed. He quotes Chapter 55B, Section 7, which states, "Objections to certificates of nominations, nomination papers, or withdrawals for the town offices or petitions for local ballot questions shall be filed with the town clerk within 2 working days of the last day of filing such nomination papers, withdrawals, or petitions, or of the day which a certification of names on the petition must be completed, whichever is later." He then points out that the affidavit is the beginning point. The end point is when the actually petition was filed. The petition was due on March 11th, March 12th. We filed our objection to this on March 11th, so it was timely. Also, he is going to, has in his brief, and I'm sure in his oral argument, will say that swearing to is, the sworn to is sufficient. We totally disagree, and the courts disagree that it doesn't have to be notarized, but does at least has to be signed under the pains and penalties of perjury. This document was not notarized, nor was it signed under the pains and penalties of perjury, and therefore the board should rescind their certificate of recall and cancel the special elections, which is scheduled September 1st. Thank you. And Dan, you can't have my last 10 minutes, only one of them.
Okay, so I'm assuming it's okay for me to ask a question before we move on to Dan Ray.
Absolutely.
So Mr. Newman, can I get you to repeat the specific reasons that you state that it does not comply with the charter?
It is not notarized, and it is not signed under the pains and penalties of perjury. Quoting Galvin, which is the seminal case on this type of issue.
And so that's the only two reasons that you state that it doesn't comply with the charter.
Yes, it is not, in Galvin, there was, in the alleged affidavit, it had the word affidavit twice, but the courts found, and I quote, "We hold that the affidavit seeking recall neither notarized nor signed under the pains and penalties of perjury do not comply with the charter." And their charter stated, their charter is very similar to Reading's, and I'm quoting their charter now, the Winchester. It says 200 or more voters may file with the town clerk an affidavits containing the names of the officer whose recall is sought and a statement of the grounds on which the petition is based. That's Winchester Charter, section 7-13. So it's very similar to the Reading charter, and the affidavit is not sufficient, and it did not comply with the charter because it was not notarized, nor was it signed under the pains penalties of perjury.
Okay, thank you.
You're welcome.
Any other questions of the board before we move on? Hearing none. All right, thank you, Mr. Newman. And now we're going to go into Mr. Ensminger.
Thank you.
Thank you very much. Hello, everyone. Yesterday, the petitioners filed a document, PET 9, which was the petitioner's argument memorandum in defense of the affidavit. Today, I will use my argument time to highlight the major points made in that document. Petitioners demand that the town of Reading, its town clerk, and its board of registrars comport their conduct per the authority and limits of conduct and certification described in the charter, Massachusetts general laws, and case law cited by Reading Town Council in his instructions to the board of registrars. Further, petitioners demand that the town of Reading and its board of registrars deny Vanessa Alvarado her claims seeking to invalidate the sworn affidavit and attendant signatures previously certified by the registrars. We respectfully submit that the registrars should grant the relief demanded above for at least the following reasons. And if Laura, you could bring up my extended timeline, please, PET 11. First, the renewed objection to recall petition was not timely filed with the town in accordance with MGL Chapter 55B, Section 7. The yellow highlights in the recall timeline show, pursuant to Section 811.2 of the Charter, that on February 20th, 2020, an affidavit sworn by John J. Arena and with the required 250 signatures was filed with the town clerk requesting a recall petition for Vanessa I. Alvarado. The town clerk, pursuant to Section 811.2, within 24 hours of receipt of said affidavit, submitted it to the registrars, who forthwith certified thereon the number of signatures that are names of voters. The registrars, having certified 250 or more voters, including at least 25 from each precinct, on February 21st, 2020, the town clerk issued a recall petition to one of the first 10 names on the affidavit. On March 11th, 2020, Attorney Newman submitted a renewed objection to the recall petition, which the word petition is used, but actually referred to the affidavit that was filed by the town on February 20th, 2020, because, quote, the affidavits failed to meet the requirements of the Reading Home Rule Charter, and you should not have issued these petitions, unquote. This was a full 18 days following certification of the affidavit by the registrars. Note also that this delayed date was well before the Reading Town Manager closed Town Hall on March 16th, 2020, and well before Governor Baker issued the stay-at-home order on March 24th, 2020. Petitioner respectfully submits that the present COVID-19 situation had zero bearing on the objecting party's inability to meet the statutory deadline imposed by MGL Chapter 55B, Section 7. That piece of MGL states in part, and I believe Counselor read this too, objections to certificates of nomination, nomination papers, or withdrawals for town offices, or to petitions for local ballot questions shall be filed with the town clerk within 2 working days of the last day fixed for filing such nomination papers, withdrawals, or petitions, or the day on which certification of the names on a petition must be completed, whichever is later, except where town charters provide otherwise. So let's look at that. The affidavit is a necessary first step in the production, the affidavit's a necessary first step in the production of a recall petition, and so is a vital part of the petition process. The 18-day delay in filing the objection is well in excess of the required 2 days, measured from the date on which certification must be completed, February 21st. Town of Reading Board of Registrars and Town Council have no discretion to accept obligations in violation of MGL Chapter 55B, Section 7 time requirements, nor to unilaterally waive the express provisions of this applicable state law. Nonetheless, the Reading Board of Registrars did so upon the advice of Reading Town Council. This would have been in their April 8th meeting on the chart, and voted to accept this now 18-day delay. Excuse me. Petitioner further notes in the non-timely filed objection to the affidavit of February 20, 2020, which objection was filed late on March 11th, 2020, that the objecting party cited in the case, which it is named as Commonwealth versus Strange, 2007-MBA-493, no particular page given, as supporting a requirement that, quote, the names of all registered voters who have signed affidavits for the purpose of a recall petition be certified by the Board of Registrars, quoting from the objecting party's March 11th, 2020 document at page 1. Despite best efforts, we could not locate any Massachusetts case having that name. However, petitioner did locate a case which may or may not have been the one intended by the objecting party, namely Mora v. Strange, number B0701335, Mass. CMMW, September 26, 2007. I believe this is document PET 10. You don't need to bring it up, though. This case involved a party, Mora, whose recall was being sought and who filed timely challenges to documents filed in connection with that recall. Mora is instructive because it states that under GLC 55B, Section 7, Mora had 2 working days from the last day, quote, on which the certification of the names in the petition must be completed, unquote, to file his objections. Further, in the Mora case, it states that both the August 13, 2007 letter of objection and the August 20, 2007 letter of objection satisfied the deadline imposed by GLC 55B, Section 7. That is, the objecting party's own case law, assuming this was the case intended, clearly supports that the statutory limits delineated MGL Chapter 55B, Section 7 apply to all objections filed by the opposing party, including but not limited to the ones filed on March 11, 2020 and April 6, 2020, with respect to the affidavit the petitioner filed with the town clerk on February 20th, 2020. The objecting party cannot pick and choose which parts of the state law it wants applied to the present facts. It is undisputed that the 2 business day requirement of MGL Chapter 55B Section 7 was not met in this case, and we respectfully submit that it was a clear error for the Reading Board of Registrars, upon the advice of Town Council, to waive the timing requirements of state law. Accordingly, any objections to the affidavit filed after February 26, 2020 should be rejected by the Board of Registrars as being in noncompliance with state law. Laura, you can take that timetable down now. That was my first major point. Second major point, the registrars have no authority or jurisdiction under state law to evaluate the validity or sufficiency of an affidavit itself or its specific language. Town Council, in his opening remarks, addressed some of the aspects of this. The town website lists the registrar's duties as follows, as derived from multiple sections of MGL Chapter 51, and I'm quoting directly from the town the registrar's page on the website. Quote, to certify names on nomination papers, inactive petitions, referendum petitions, recount petitions, and public policy petitions. Registration of new voters, conduct election recounts, update and posting of voting lists, and processing absentee ballot applications. Oversee the annual town census and prepare lists generated from census information. Close quote. The authority for registrars to evaluate the validity of an affidavit simply does not exist in the charter nor state law. Thus, the Board of Registrars hearing is not a proper venue to hear concerns raised relating to the validity or sufficiency of the affidavit filed in the present action, because the Board of Registrars has no legal jurisdiction over deciding on whether an affidavit is sufficient under the law. For at least the above listed 2 reasons and the arguments made herein, the petitioner respectfully requests that the registrars deny the objecting party's objections to the affidavit, and respectfully requests that the registrars vote to allow the September 1, 2020 recall election to proceed. Now let's go on to the specific arguments in defense of the affidavit. Again, on March 11, 2020, Attorney Newman submitted a renewed, this is the title, renewed objection to the recall petition, again meaning the affidavit, filed by the town on February 20, 2020, because, quote, the affidavits failed to meet the requirements of the Reading Home Rule Charter, and you should not have issued these petitions, close quote. As a preliminary matter, petitioner refers the Board of Registrars to the general arguments just made in connection with the defense of the affidavit, because all such arguments likewise apply to these specific arguments. In addition, petitioner is puzzled by the opposing parties referring to affidavits in plural, because the Reading Charter at Section 811 calls for a single affidavit put forth by at least 250 voters and not multiple affidavits, and I believe Town Council in his opening remarks agreed with that interpretation. Below is petitioner's rebuttal against each of the 4 points raised in the objection. I'll first read the opposing party's point. First point, quote, all the affidavits are invalid in that they do not meet the requirements for affidavits, in that they are not signed under the pains and penalties of perjury, emphasis added. See Galvin v. Town Clerk of Winchester, 369 Mass 75 from 1975. In parentheses, affidavit must at the very least be a statement containing a statement made under the pains and penalties of perjury, close quote. The objecting party contends that the purported affidavits are all facially defective, as none are signed under the pains and penalties of perjury. Petitioner's response to that. Pursuant to the Town of Reading Home Rule Charter, Section 8.11, the recall procedures provision for the recall of elected officials is detailed. The charter anticipates an affidavit process followed by a petition process, and the requirements for each are contained within the charter subsections. The affidavit process requirements are given in the Reading Home Rule Charter as follows, quote, 250 or more voters, including at least 25 voters from each of the precincts into which the town is divided, may file with the town clerk an affidavit containing the name of the town officer whose recall is sought and a sworn statement of the grounds upon which the affidavit is based. The town clerk shall, within 24 hours of receipt, submit the affidavit to the Board of Registrars of Voters who shall forthwith certify thereon the number of signatures that are names of voters. A copy of the affidavit shall be entered in a record book to be kept in the office of the town clerk. Close quote on the quote from the charter. The Reading Charter thus requires the town clerk receive a single affidavit which contains 3 elements. 1, the name of the officer to be recalled. 2, a statement as to the grounds of the affidavit signed and sworn by the affiant before an officer of the town charged with administering such statements, in this case, the town clerk. Third, the signatures, Third point, the signatures of 250 or more voters, including at least 25 voters from each precinct of the town. At the bottom of the affidavit, and you have it up, Laura, that appears on the first page of each signature sheet, just above the signature area is the phrase "sworn this 14th day of February 2020," followed by Mr. Arena's signature. This oath was administered by Laura Gem, town clerk, and her signature appears at the top right. I don't think it's on the specimen, but there's at least a printed seal with your signature and the date 2/14/2020 on all copies of the affidavit that went out. I don't know if it's shown here. It's not, but that is what was on it. I don't know if Mr. Newman's Exhibit A might have that, if you can find that, but I'll keep going on. In any case, because of all those points, the affidavit is sufficient in all ways with the requirements contained in the Reading Home Rule Charter. Second point made in the objection by the objecting party. Many of the signatures on affidavits are non-genuine and should not have been certified. Petitioner response: no evidence of any such nature has been presented by the objecting party to support this allegation. As with the objections to petition signatures, which have now all been withdrawn, but I think you still need to take a formal vote on that. Petitioner expects that the objecting party likewise must withdraw this particular objection. It is the objecting party's duty to prove the validity of this allegation, and no such proof has been submitted to this body. So petitioner respectfully requests either that the objecting party withdraw this objection or that the board overrule this objection. Third point from the detailed objection. Objecting party, there are less than 250 affidavits that state the grounds upon which the petition is based, as required by section 811.2. I think we've been over this. There's only one affidavit document required. I don't think I need to dwell on the detail there. Town council has backed that up. Fourth major point, objecting party, quote, Massachusetts law requires that the names of all registered voters who have signed affidavits for purposes of initiating a recall petition be certified by the Board of Registrars, see Commonwealth v. Strange, 2007 MBA 493. In the present case, the town clerk, who has no authority under the law to certify registered voters, attempted to certify names of purported registered voters. Petitioner response: the state law on certification of signatures, 950 CMR 55.02, states at paragraph 12, the registrars, quote, the registrars may authorize the office employees of the city or town clerk's office, including the city or town clerk, to perform all the actions required by 950 CMR 55.02 and by MGL Chapter 53, Section 7. This authorization may be accomplished by, among other things, a vote of the Board of Registrars, unquote. This authorization did take place by a vote of the registrars at a meeting held earlier in 2020. I haven't been able to find the exact minutes, but I was told by one of the registrars that did happen. Summary: in view of the remarks and citations above, and upon information and belief relating to the evidence that the registrars are receiving and considering during the hearing, petitioner respectfully submits that all of the objections of the objecting party should be dismissed and that the affidavit upheld as valid. Accordingly, petitioner respectfully requests that the town of Reading and its Board of Registrars deny the objecting party its claims to invalidate the affidavit that was the basis for the recall petition. Thank you very much. So I have.
Shit. Okay. So before we continue on, I as a member of the board, have a question of Dan. That one of the things that you mentioned is that the Board of Registrars didn't have the right to waive requirement of state law. What exactly were you referring to?
Well, it's 55B, Section 7 has those, and council and I disagree on the application of that statute. But you would have a right to extend, once something's been timely filed, you could take more time to get a detailed response as you did on the petitions. But you don't have any right to extend that fundamental 2-day period. That's in state law. That's not waivable by a Board of Registrars. That's my point.
And are you stating that we did that?
I'm stating you did that.
Okay. Any questions of the board? Nancy?
This is a lot of information and it's all coming at once. And I have to say, it's very difficult to process it. That's the first thing. So I'm going to start with Dan's most recent fact that he stated. He says, he said something about a meeting at which we voted, and if he could just go back and say what we did. This was the one that he said he couldn't find the specific date, but someone had said that we discussed it. Can he just explain that again?
So before Dan answers that, he's referring to the meeting that we had in February, where when you were very first appointed, Nancy.
Yeah.
We had the meeting and did a vote allowing me to do the tasks of the Board of Registrars and allowing me to use the stamp with your signatures. The minutes were approved by the board. Apparently they have not been posted, so that I can pull those up as soon as I find them, but that's what he's referring to.
But what is what was the content? I mean, why, Dan, why were you referring to those minutes? In what context?
Oh, one of the complaints in in objecting party's initial filing, I have it here in print. Let's see here. He made that exact allegation in his fourth point. This is, the first filing that you received.
What allegation?
That the town clerk had no authority to certify the petitions. He said that in his filing. It's back. It's in there. It's I don't know which one it is. It's the one on the 11th. You might bring it up, Laura.
I guess I don't. I mean, all we really did at that meeting was gave Laura permission to use our signatures. So right. I'm not certain what you're talking about.
So that's true. There was several votes taken, and for some reason I'm not finding the minutes, but I will find them. But there was several votes taken. One being that it authorized me to do the tasks of the Board of Registrars, such as certify nomination papers. The other, one of the other votes was authorizing me to use the stamp on those nomination papers.
If I may, and in fact,
Dan, do not interrupt me. When I when I recognize you, you may speak. Nancy, do you understand what I'm saying?
Yes. So you're saying that we authorized you to certify, and we authorized you to put our names on the stamp to stamp the certification.
Correct.
So I'm just curious why Dan is bringing this up. I'm sorry if I'm being thick here, but
okay. Now I'll turn it over to Dan.
Yeah, I'm looking for the exact. I would like you to bring up it's one of the basic documents. Trying to find it quickly here. Oh, it's basic -4. I think that will clear up Nancy's question. If you could bring that up. If you would scroll down to point 4. Right there. Massachusetts law requires that the names of all registered voters who have signed affidavits for purposes of initiating a recall petition be certified by the Board of Registrars, see Commonwealth v. Strange. In the present case, the town clerk, who has no authority under the law to certify registered voters, attempted to certify names of purported registered voters. On the back of every single one of both the affidavit signature sheets and the petition signature sheets are the signatures of 3 of the registrars through a stamp. That's Harry Simmons, Chris Holmes, and Laura. Nancy, I guess you were too new to be on the stamp, but they usually pick 3 because that 3 are required. So you did give her authority, and this is a completely fallacious accusation.
So Nancy, just to clarify,
Okay.
the reason why your signature was not on there is because we did not have the stamp as of yet. You had just been appointed.
Right, that's what I assumed.
What the heck I did with the minutes?
So the way that we, okay. So the way that we have this organized, we can't go back to Dennis and have him speak to this?
We
Is
can,
that-
we can in a moment, yes, not just
Oh,
yet.
okay,
Right now, it's, if the board has any questions,
okay.
go ahead.
This issue of single affidavit versus 250 affidavit, can you explain that a little bit more? I don't, there was a single affidavit. I don't know. Can you explain that a little bit more? What's the reasoning? What's the problem here?
Who is the question addressed to?
Oh, Dan, I thought we were still on Dan.
I'd be happy to defer to Ray because he raised that issue at the outset.
So, all right, I'll give it a try. The charter provision says 250 or more voters, including at least 25 voters from each of the precincts into which the town is divided, may file with the clerk an affidavit containing the name of the town officer whose recall is sought and a sworn statement of the grounds upon which the affidavit is based. The question is that we're talking about here is how many people have to swear to it? The plain English interpretation of this sentence is that 250 voters have to submit the affidavit, but it doesn't say that 250 voters have to swear to the affidavit. So my interpretation is that as long as there is an affidavit and it is properly sworn, then there only needs to be one. There doesn't need to be 250.
Thank you. Chris, you, go ahead, Nancy.
So then who's responsible? So John Arena is responsible for all those signatures since he was the one that filed for the affidavit? Is that he's responsible for affirming that all those people signed and
He is only
under
responsible.
pains and penalty of perjury.
Okay,
So
so
he's
he's
held
only
responsible for the 250, sorry.
Okay.
He's only responsible.
he is not responsible for swearing to the validity of the 250 signatures. The only thing that he swore to is the statement of the grounds upon which the affidavit is based. That's the only thing he is sworn to. The signatures were reviewed and certified in the same way that the signatures on the ultimate petition were reviewed and certified too. That is to say, the signatures were submitted to the to the same process that you would do for any filing of this type before the Board of Registrars.
Go ahead, Nancy.
So, legally, an affidavit, if I'm, so really you're saying the only affidavit is that original one that does not have any signatures on it? Right? Is that what you're
No.
saying? That's the, no?
It has John's signature on it.
It has John's signatures on it.
That's right.
But the other 250 do not have to, but aren't they signing a document that says affidavit? Or that the charter says has to be an affidavit?
The charter says the document has to have two things. It has to have the name of the town officer whose recall is sought and a sworn statement of the grounds.
Which it does.
But when you sign an affidavit, aren't you, isn't that a little bit more serious than if you're just signing a, you know, a piece of paper with a statement on it? An affidavit, doesn't that usually legally require some kind of language that states that you are the pains and penalty of perjury?
Well, there are two ways that can be done. There is a statute. So originally in the common law, the way an affidavit had to be signed was the person had to appear before a town official, usually the town clerk, and the town clerk would have to say would have to witness the signature and ensure that it was signed under pains and penalty of perjury. That's the sort of traditional way it was done. There is a statute that says you can substitute for that a statement saying, I'm swearing to this under pains and penalties of perjury. In other words, you don't have to appear before the town clerk and swear under pains and penalties of perjury. You can just sign it with a statement at the bottom. I haven't heard any evidence from either side as to the way that the signature was made. So perhaps Laura can explain the process that was followed in John Arena signing the document.
Okay. So Chris, you had your hand up. Did you have any questions?
Oh, I was just trying to, when she was wondering about the stamp, we gave you the authority.
Sure.
Chris,
Chris.
you're muted. You need to unmute yourself.
I just wanted to, clarify that with the signature because, I had my hand raised quite a while ago and I was there that day, of course. And I remember it was the same day that we swore her in for the first time. And you explained that you had the stamp, which was easier, and that you, rather than calling every single one of us in for every vote, that you would do it, for us. And I just want to explain that.
No, I understand that. It was,
Okay.
it was the statement
Right.
on the opposing,
Yeah.
the
They were going to make a
objectors.
new stamp eventually.
No,
We didn't-
yeah, it was just the statement
Yeah.
on the other document,
Okay.
so that
No, that
I
was it.
confused. So I don't know what happened to my hand on my, that's why I keep raising my hand.
Down to bottom.
That's
Yeah.
okay, it works.
It's not there. But anyways,
Participants.
let's move on. Harry, you have your hand up?
I did. I don't know if we want to move on from this, but I have a question on something that Dan pointed out, a case that did kind of disputed the two cases, or at least one of the cases that Mr. Newman put out. He cited the Murray case, and he pointed out that that case under the state was proved not to be applicable. And I think he said something about he could not find the case. Doesn't that have some effect on this? Dan, did you find the case? Is it a real case?
The real case. May I?
Go ahead, Dan. Actually, I'm going to stop us right here for just a second, if I could. The presentations by both parties has been concluded. Is that correct?
Yes.
Okay. Mr. Newman, is that correct?
Yes.
Okay. So now we're going to ask the hearing participants if there's any other requests before the board begins its deliberations, because it sounds like we've already started deliberating, and I'd just like to go ahead and before we do that, just make sure that there's any other requests before the board begins its deliberations with respect to the argument and evidence of this hearing. Dana, you have anything?
I do. I think someone had asked a question. It might have been Ray, to you, to describe the.
Dan, before we go to that, can we answer this question?
What?
Is there any? I now ask that the hearing participants, if there are any other requests before the board begins its deliberations with respect to the argument and evidence of the hearing. Do you have anything else that you need to present before we deliberate? Go ahead.
Me?
Dan? Yep.
Town council had asked you a question, but it didn't get answered regarding the process for gathering Mr. Arena's signature. Ray, do you want to repeat what you had asked?
I will answer that question after when we get into the deliberation.
Thank
Dennis, did you have something?
Yes, if I might make it a little bit easier. First of all, Dan has referred to my objection filed on March 11th as the renewed objection. Originally, it was the objection to recall petition. The renew one was when I redid it several weeks later. There are 4 grounds, 1, 2, 3, 4. I would say that it might make the deliberations easier if I withdraw grounds 2, 3, and 4. There seems to be a lot of confusion on those. So it comes down to whether or not the board will uphold the objection on number 1, which is that the affidavit does not comply with the Reading Town Charter because it was neither signed under pains and penalties of perjury nor notarized, so it was insufficient affidavit. If the board sustains that objection, then they should rescind the certificate of recall and suspend or cancel the recall election on September 1st. Thank you.
Okay, thank you. So we've already started deliberating, but I'm just going to go ahead and make sure that we are all on the same page here. The board will now deliberate concerning the evidence and arguments presented during the hearing because the select board member Alvarado has withdrawn her objection to the recall petition, and the only objections pending before this board are those addressed to the recall affidavit. So now the board will open deliberations, which we already have, but now we're official. And I just want to, we can go ahead and carry on the conversation, but before we do so, I will answer the question. I believe, Ray, you had a question of me of how we went about getting the signature for John Arena on the affidavit. Is that correct?
That's correct.
Okay, so John Arena came in with the affidavit, which is this document here. He was in town hall. The affidavit was signed by me and dated as the date of the affidavit. John Arena signed the document in front of me where it states sworn at this 14th day of February 2020, with me stating that I need you to sign this in front of me under the pains and penalty of perjury. Did that answer your question, Ray?
Yes, it did.
Okay. Any other questions that have been unanswered? Okay, so then I'm going to go ahead and refer to the board. If in any questions that you have of Mr. Newman. I know that Nancy, you had asked that you would like to address Mr. Newman with a question. Do you remember what that was? Okay,
You have to unmute yourself.
Nancy?
I think he just withdrew it.
Okay,
The statement that I was questioning, is that correct?
Yes.
Okay.
Any other comments from the board? Go ahead, Nancy.
So are we still asking questions of Dan and Dennis?
Yes.
Oh, okay. I have a question of Dan. He talked about the timeliness of the objectors submitting all of the correct documents. And if he could just go over that again, exactly which specific one was late according to him, and which specific ones did not meet the timeline.
Go ahead, Dan.
Thank you. Could you put that timeline back up again? That might be helpful here.
Was that petition 11?
PET 11, right. Again, Nancy, and you might want to have PET 9 at the ready, because that has a lot of the text of what I just spoke to. You don't have to show it right now. I'll go over this. Is there a question there, or some noise in the background?
No idea who that is.
Okay, I'm going to read the appropriate section of MGL Chapter 55, Section 7. Objections to nomination papers or withdrawals for town offices, or to petitions for local ballot questions, which is the applicable piece here, shall be filed with the town clerk within 2 working days of the last day fixed for filing such nomination papers, withdrawals, or petitions, or of the day on which certification of the names on a petition must be completed, whichever is later. And I stress that the affidavit is a necessary first step in the production of a recall petition. Other towns, it's a 1-step process, okay? Here it's a 2-step process, but it's a vital part of the process. There's an 18-day delay between February 21st and March 11th, the 2 dates in yellow there. And therefore I'm saying that is what, if 55B Section 7 is appropriately applied here, then town council advised this board to disregard state law. That's my argument. You can deliberate over what you think of it, but so you should not have accepted on your March 8th meeting the affidavit objection as being timely. That's my point.
Oh, okay. And that was that.
Hang on just a second, Nancy. Ray, do you have anything to add to that comment?
Well, I certainly didn't advise anybody to disregard state law. It's not entirely obvious that the statute applies to recall petitions, but even if it does, I think Dennis has the better argument on the timeliness issue because it measures the time from the date in which the petition is filed, and doesn't really say anything about the affidavit. So, in my view, the objection was indeed timely filed because it was filed on the 11th and the deadline was the 12th.
I understand.
Okay, Dennis, you had your hand up?
Yes, I was going to say exactly what Ray said, so what Ray said.
Okay, good. Nancy, go
Make
ahead.
things go faster that way.
So Dan, is that the only objection? Is that the only untimely? Is that the only thing that was untimely according to your calendar?
That was one of my two general critiques, but there are the four specific ones also that I've spoken to. Now, three of those have been withdrawn. And I guess the one we're really still talking about is the first ground, whether or not the affidavit was properly sworn. And you just heard testimony from Laura to that effect, that it was properly sworn, in my view, based on what she said.
Go ahead,
Well,
Nancy.
Yeah, I mean, I guess I have no, I mean, it does seem that way, but then I think the additional question to that is the 250 people that signed the affidavit that Arena swore to did not make that same commitment. And according to Ray, I understand in the old days, used to come into the office, but I'm assuming that then that was maybe transferred to, it needed to be on the document. And I know that Dennis has referred to the case in Greenfield, which basically throughout the affidavit, because it did not have that language on it when they were seeking their signatures. So why wouldn't that apply in this case?
Ray, hang on, Ray, you had a comment?
Yeah. Well, as I indicated, there is a statute that allows one to substitute the words signed under the pains and penalty of perjury for the requirement that they sign before a town official. In this case, they did sign before a town official, so the statute is not necessary. It appears to me as though Laura's stamp certifies that that it was indeed signed under pains and penalty of perjury, and that's what she said her procedure was.
I guess I'm confused. Mr. Arena signed under the pains and perjury,
Yes.
but the 250 people that signed the affidavit did
Yeah.
not sign under the pains and
That's correct.
penalties of perjury.
That's correct. That's correct. So,
And what
as
I'm
I
hearing-
indicated to you before, you only need one person to have sworn to the affidavit, and that one person in this case was John Arena. And just so we're clear, the objection that was made asserting that there needed to be 250 such sworn statements has now been withdrawn. So Dennis is no longer putting that forward.
So Nancy, just to clarify in non-legal terms, the 250 signatures are signing the affidavit and requesting the recall. They do not need to sign it in front of anyone, witness notarized, or have any, or do it under the pains of penalty of perjury. Only the one signature that's requesting the affidavit needs to do it as a sworn statement.
What about the Greenfield case? How does that apply?
Well, I don't know what the evidence was in the Greenfield case, but it suggests to me that it does not appear as though anyone asserted or anyone disputed that there was no signature under pains and penalty and perjury.
Madam Chair.
There's been others that have had their hands up first. Go ahead. Mr. Newman?
Yes, thank you. Although, Laura, you signed that on the face of the document, which is circulated to voters in Reading, was circulated over a period of 21 days, approximately. On the face of it, there is no indication that it was signed under the pains and penalties of perjury, nor was it notarized. If someone is a notary and they sign someone signs it in front of them and they just sign their name, they have to put their stamp on it. They have to indicate that they're a notary and the date that their notary ends. And there's no such indication on this alleged affidavit. It was not. I don't think it's sufficient. It does not comply with the Reading charter that it be an affidavit that is an affidavit. It is an alleged affidavit and is not either notarized or signed by Mr. Arena under the pains and penalties of perjury.
So I would just like to point out that when this affidavit was issued, it was signed in front of a public, Dan? It was signed under the public, in front of a public official. There's town seal was on top of my signature. So there's no, in my opinion, and Ray can step in, there is no need for a notarization because it was signed in front of an official and the town seal was on there. Am I correct, Dan? Ray?
Yes. And I'd just like to add one more thing. And that is the Town of Greenfield situation is not an actual court decision. It is an opinion of town council invalidating the petition. So it doesn't have any legal precedent that we can follow here. It's just an opinion. And with all due respect, I think you should not assign it any greater weight than the opinion of the town council that you have.
Say that last part again.
So, unlike the other cases that we've been talking about today, that were actual court decisions, the document that is cited with respect to the town of Greenfield is not a court decision. It's just an opinion of the town council.
Mm-hmm.
Okay. So I don't know what circumstances gave rise to that opinion. I don't know what facts other than those that are cited there apply. What we have here is a circumstance that seems to be distinguishable, but and that is that the town clerk did indeed have the affidavit signed in front of her under pains and penalties of perjury, and then affixed her town seal to it, which is the equivalent of certifying the document, which is the equivalent of notarizing it.
Okay. Harry, you have your hand up?
Yes. I brought up the Murray case as one of the cases that Dan had said proved to be not applicable. And he wasn't sure. I think that applied to the Winchester case, which was a court case. He said he had trouble finding the case. Is there such a real case, and did you find it?
Yeah, more of V Strange. It's one of the attachments. I think that's PET 10. Want to bring that up, Laura?
Sorry to interject. I can clarify that Mora v. Strange is a court decision. It was decided by the Superior Court from Bristol County.
Massachusetts?
Yes.
Okay. Dennis, go ahead.
Yes, Laura, you mentioned that you, the seal is there. I have a copy of it, so I can't really tell. Is that, I see your signature and the date 2/14/20. It seems to be on letterhead, but not a seal. Did you actually apply a seal? It just seems to be the letterhead. And although it's a picture of the seal, I don't think it's the town seal.
The town seal was applied to my signature on the original documents it was given to Mr. Arena.
Thank you.
Go ahead, Chris. Chris, you're muted. Here, I'll unmute you.
Okay. It seems to me that everything was met according to the way it should have been done. Arena came in, he signed it under oath in front of Laura. I don't know, I mean, as far as the 250 people, we did that according to the way it should have been done, or they did it. I don't know why there is a question of this. This is Reading. This is in Winchester. Our town charter is a little bit different. I think we're beating a dead horse. And I think we should accept that and move that we accept the affidavit and go ahead with the election.
Okay. And Dennis, you still have your hand up?
Oh, I'm sorry. I
You're
forgot
good?
to lower my hand. Sorry about that.
Okay, that's all right. Harry, you have your hand up? Okay, Nancy?
So going back to the timeliness, so if the March 8th meeting, the document was within the time frame, then really that Strange case would apply, because Dan, I think your objections to that was simply it wouldn't apply because what was submitted by the opposing party was not done in a timely fashion. But it seems like it was done in a timely fashion.
Where's Dan?
Okay, I made my argument on that, and you're free to deliberate.
Thank you. Any other comments from the board? Are we good? Nothing from the board? Are we ready to take a vote? Go ahead, Nancy.
I feel very uncomfortable taking a vote right now on this, because there's a lot of information that needs to be digested, and there's a lot of contrary opinions here. So I do not feel comfortable taking a vote tonight.
So what would you suggest?
I'd say that perhaps that we at least have a third meeting or a second official meeting to make sure that all the questions are answered. This is a lot of information to digest. And, as Chris said, there's both sides have a viewpoint one way or another. And town council's viewpoint is in there, which was quite clear in the beginning. I actually would like to have that in writing. I'm just not comfortable. That's my own personal opinion.
So one thing that was not mentioned in the beginning of this that probably should have is that let me think on that statement for just a moment. So let's ask this. Is the board in agreement that we should adjourn and come back tomorrow to take a vote? Is the board in agreement with that?
No,
Yeah, yes.
I'm not, no.
Ray or Brian, do you have a comment on that?
Sure. If at the end of the day, it is always better for people to feel comfortable that they have had a chance to consider the arguments and to weigh them, that they have deliberated fully before they take a vote. So I don't object. I don't think it's improper in any way to decide today that you will renew your deliberations at a future meeting, tomorrow or whenever, and take a vote at that time. It's not necessary it's not essential that you deliberate only today and vote today. If there are people who feel as though they need additional time or additional information, understand the hearing part of the evidentiary part of this hearing has been closed, but we have been pretty liberal about allowing Dennis and Dan to answer questions. And so if you want to deliberate some more tomorrow, you can do so. I just would caution against using that as an opportunity to bring in additional evidence.
Yeah, that's it. Bring in additional evidence.
So before we go any further, I'd like to just state that, as Ray just pointed out, is that at this point, it's a matter of deliberation amongst the board. No further evidence may come in, but I'd also like to point out that we are looking at this as a board of the evidence that points to the facts and the truth, not necessarily towards the political beliefs. So I just want to make sure that that's clear with the board, that we need to look at the evidence of the facts. And whether we vote on that now or you have time to sleep on it and we come back again tomorrow, that's up to you. I'll leave that up to you.
Laura?
Yes, Chris, go ahead.
Again, if we read everything the way it has been, the point of contention was that it was not signed. The affidavit was not signed under, penalty or perjury or whatever in front of you. And we got that cleared up. That was on the up and up. And as far as the 250 people that signed, they did. Their signatures were approved. And then the other points were withdrawn as far as they were trying to, or said that the signatures were not correct, or that all was erased. And that was the whole thing. I don't see what more we have to deliberate on except to go and talk to other people and get more opinions. And already we can't bring any more evidence in. So I don't know what is the point of going in any further if we can't have any more new evidence into it. And they have met whatever was required according, or the objections. So I don't know why we couldn't vote today. I don't understand it.
Okay, Dan, you have your hand up?
I had a point of order, Madam Chairman. Seems there's one loose end that wasn't taken care of, and that would be to take a formal vote to accept the withdrawal of all objections on the petition. Ray, I don't know if you would agree with that. It might be a good housekeeping item to do.
It's my understanding that that motion is not a required motion, and it's already been accepted by the board. So we're moving on.
Okay.
Wow.
Any other comments to the board?
Yeah. I got to get my hand up somehow.
That's okay, Harry. I'll recognize you. Go ahead.
All right. Thank you. It's true we did cover a couple things in the legal documents, the arguments that did come up from both Dennis and Dan. I think it's more than just sworn to. The documents are quite lengthy, and I would like to have a chance to look over those documents this evening. And so I'm uncomfortable with just ending it right here.
Okay, any other comments to the board? Okay, so what I'm going to request then is that I'll entertain a motion to adjourn until tomorrow, July 1st at 4 p.m. I'm going to state that if we do adjourn and we reconvene on July 1st at 4 p.m., there will be no more evidence presented, and there will be no more deliberation other than with the board. The board themselves will deliberate. There will be no more comment from any of the other participants. With that said, before we take a vote to adjourn, I'd like to allow the participants to make any other additional comments they would like the board to consider. I'll give you just a few minutes so that you have your opportunity to speak before we adjourn and deliberate again tomorrow. Anybody?
I'd like to go first.
Okay, go ahead. Go ahead, Dennis.
I have nothing to add. I want to just thank the board again for their deliberation and their time. And I know this has been a long and tedious process and a lot of work on all parties. So I want to thank you all, and I'll see you tomorrow. Same time, same channel.
Thank you, Dennis.
All right, thanks. Dan, do you have anything else?
I do. Just to summarize what I think has been put into evidence and questions asked today. If you look at the complaint filed against the affidavit in Basic 4, all four underpinnings of that complaint have now either been withdrawn or pretty much gone. 2, 3, and 4 were withdrawn by the objecting party, and we heard testimony from the town clerk that the affidavit was signed before her under the pains and penalty of perjury. So I think this is a closed case, in my opinion.
I do too.
Any other comments from the board? Nancy?
I like what you said, Laura, but I'm also wondering, given a chance to look at all this information again, and it's a lot of paper. I've gone through like at least a ream of paper and making copies of all this. And should we have a question after reviewing what was presented today? I'm just wondering if tomorrow when we meet, can we say the first 20 minutes might be asking any follow-up questions to the participants that might have arisen over looking at the information in the next 24 hours?
So I have what I will allow is deliberation amongst the board, questions amongst the board of the participants. What I'm referring to is that the participants may not make any statements. They may answer questions.
Okay.
there will not be any more statements or evidence presented by the participants.
Okay, thank you. Thank you.
Ray, am I okay with that?
You are A number one.
All right, so if there's any other comments amongst the board, I'll entertain a motion to adjourn until July 1st, 4 p.m.
I'll make a motion to adjourn.
And do I have a second?
Second.
And Harry,
Adjourn. Yes.
Chris,
Yes.
Nancy,
Yes.
and we are adjourned at 5:50 p.m.